Okay, ready to dive deep. Today, we're tackling criminal prosecution, but with a twist. We're getting the inside scoop straight from a Ugandan High Court judge.
Oh, yeah. Sounds interesting.
We've got this presentation Judge Vincent Wagona gave at a prosecutor symposium. It's like a masterclass in winning case, taught by the person who decides the verdict.
Talk about an insider perspective. Does he hold anything back?
Nope, not at all. He dives right into the mistakes prosecutors make, the tactics defense lawyers use, and even how culture plays a role in Ugandan courts.
I wonder how much that translates to other legal systems. I bet there's some universal challenges.
You're right on the money. One thing that really stood out to me was Judge Wagona's emphasis on this idea of weaving together the law and the facts throughout the whole process.
Yeah.
From picking charges to presenting evidence to those final arguments.
He's basically saying you can't just rely on having a solid legal argument. You need the facts to back it up, right?
Exactly. He says you could have a perfect legal strategy, but if the evidence is weak or it doesn't match up with the legal requirements, you're going to lose.
So it's like a two-pronged approach. You need both the law and the facts working together.
He even tells this story about trying to use documents as evidence when the person who wrote them isn't there. Apparently, there are these specific sections of the Ugandan Evidence Act that make it really tricky.
So it's not as simple as just showing the document to the court. There's a whole process involved.
Right. His point is you have to do your homework before you go to court. Anticipate those legal hurdles and figure out how to overcome them.
It's like failing to plan is planning to fail. Applies to so much more than just law.
Totally. Whether you're getting ready for a big presentation or having a tough conversation thinking ahead can make all the difference.
Absolutely. Another thing Judge Wagona is really passionate about is how prosecutors decide what to charge someone with.
Yeah, he's not a fan of just copying charges straight from a police report. He wants prosecutors to be more proactive.
What does he mean by that?
He says they need to really break down the crime, understand every single element of the offense, and make sure the charges they bring are a perfect match for what actually happened.
So it's not just about charging someone with something. It's about being precise and making sure those charges are legally sound.
He uses rape charges as an example, and he goes through each way rape can be committed under Ugandan law. And what's really interesting is he goes beyond the legal definition and talks about how society's expectations around consent are changing.
That's an important conversation to have. How does he address that?
He says even the idea of lack of consent is enough to establish rape, even if no physical force was used.
So it's not just about physical violence. It's about respecting someone's boundaries and understanding that no means no.
He even says that males should learn to understand a woman's no or stop, even when presented softly, and accept to take no for an answer. It's a powerful statement about how the law needs to catch up with these changing social norms.
Yeah, he's definitely making a point there. It sounds like he's advocating for a shift in how we think about and address consent.
Absolutely. Okay, so we've covered integrating law and facts and crafting precise charges. What about building a rock-solid case?
Well, what's the secret?
No surprise here. Preparation, preparation, preparation. Judge Wagona really hammers home the importance of choosing your witnesses carefully.
So it's not about just calling everyone who might know something. It's about being strategic.
You want to focus on witnesses who can directly prove the specific elements of the crime. Don't waste time with people who can only offer vague information.
It's about quality over quantity, I guess.
Exactly. And when you're questioning your witnesses, Judge Wagona says to ditch the vague prompts like, tell us what happened.
Yeah, that's not going to get you very far.
Instead, you need to guide them with very specific, well-structured questions to bring out the most important facts.
You're painting a picture for the judge and the assessors, right? Each witness adds a brushstroke.
Speaking of assessors, for those of us who aren't familiar with the Ugandan legal system, can you explain who they are and what they do?
Sure. In Uganda, assessors are kind of like mini jurors. They sit with the judge, listen to all the evidence, and then give their opinions on what the verdict should be.
So the judge doesn't have to follow their advice, but he has to consider it.
Exactly. It's an interesting system.
Like a built-in focus group, giving feedback throughout the whole trial. Now let's talk about another crucial element of building a strong case: corroboration.
What does Judge Wagona say about that?
One thing that surprised me was how much he values police officers as witnesses. He sees them as playing a really important role, especially in cases where corroboration is required by law.
I see. So it's not just about the victim's testimony. You need other sources to back it up.
He specifically mentions cases involving child victims, It's not always easy to get a solid testimony from a child who's been through a traumatic experience, but there are provisions in the Ugandan Evidence Act that allow a police officer's observations at the crime scene or even the victim's initial report to the police to be used as corroborating evidence.
So even if a victim's testimony might be considered shaky on its own, there are ways to strengthen it using other sources.
It shows how important it is to know those intricacies of evidence rules. They can really make or break a case.
Judge Wagona even uses a Supreme Court case, Livingston Soanyana versus Uganda, to show how this kind of corroboration can be used successfully to support a victim's story.
That's some impressive legal strategy.
Oh, what?
All right, so we've got integrating law and facts, crafting precise charges, choosing and prepping witnesses, and understanding corroboration.
Sounds like a lot to keep in mind.
And we're just getting started. Judge Wagona doesn't stop there. He also goes into some really practical trial tactics, but we'll save that for next time. All right, welcome back. Last time we left off with Judge Wagona dropping some serious knowledge bombs about building a strong case. Now he's taking us into the courtroom.
The nitty-gritty of trial tactics. This is where it gets real.
He starts by tackling those tricky trials within a trial, When the defense tries to get a confession tossed out, I bet that gets complicated.
It can be, but the judge breaks it down. He says, find out early on if the defense is planning to challenge the confession.
So you can be ready for it.
Exactly. Plan your witnesses accordingly, so you're not caught off guard. He also says, keep your arguments laser-focused. Don't waste time on things that don't matter.
Just hammer home the legal points that matter. No rambling on and on.
Exactly. Stay on point. And speaking of specific challenges, he moves on to handling child witnesses.
I can only imagine how difficult that must be.
It's definitely a sensitive area. First, there's the voir dire process.
Oh, voir dire.
It's basically where the court figures out if the child is competent to testify. Can they tell the difference between truth and lies? Can they remember and explain what happened?
Makes sense. You want to make sure the child understands what's going on.
Right. And Judge Wagona says, be prepared for the possibility that a child might not be able to give sworn testimony.
Meaning?
Their statements would need to be backed up by other evidence.
So again, it comes back to preparation, having a plan B.
Now, for something a little different, sniffer dog evidence.
Okay, I've always wondered about that. How reliable are those dogs, really?
Well, Judge Wagona says it can be useful. But he's definitely not saying it's a slam dunk. He points out some limitations, like if there are multiple suspects, the dog might only pick up on the strongest scent.
Not necessarily the scent of the guilty party.
Right. And weather or things at the crime scene could mess things up. Then he tells this wild story about a case where the suspect had actually spent time with the victim the night before the crime.
So the dog might have been reacting to that interaction.
It makes you think, was it a false positive or legitimate hit? It highlights why you can't just present sniffer dog evidence as if it's a guaranteed win.
So what does he recommend?
Lay a strong foundation, talk about the handler's training, the dog's track record, and make sure the court understands how to interpret the dog's behavior.
Because a dog sniffing and barking doesn't automatically mean guilty.
Exactly. You have to connect the dots. Speaking of courtroom drama, let's talk cross-examination.
The face-off. Any tips from the judge?
He's got two big ones. First, focus on the areas where there's real disagreement. Don't waste time on stuff everyone agrees on.
Makes sense. Make it count. What's the second one?
Only ask questions when you already know the answer.
Wait, how is that possible? How can you know what a witness will say before you ask?
It goes back to preparation. Interview your witnesses, study the defense's statements, and anticipate their questions.
So it's less about tricking the witness and more about highlighting weaknesses in their story.
Exactly. Judge Wagona also warns about something called sandbagging.
Sandbagging. What's that?
It's when the defense doesn't ask their witness an important question, hoping you'll bring it up.
So then their witness can give a rehearsed answer and look more believable. Sneaky.
Right. Don't fall for it. Now, what about those times when you have a hostile witness?
Someone who changes their story. Oh, that must be tough.
Judge Wagona says, don't be too quick to declare a witness hostile. Only do it if there's a clear contradiction.
Because it's risky, right?
You could lose their whole testimony. You have to weigh the pros and cons. And even then, follow the procedure. Show the court the inconsistencies, get permission from the judge.
It's not something to take lightly. Okay, what else does Judge Wagona cover?
He talks about something that sounds like it's straight out of a detective novel. Dying declarations.
Ah, those famous last words. But isn't that hearsay?
Usually, yes. But Judge Wagona points out that Ugandan law is more flexible than the traditional English standard.
So it's not just limited to deathbed confessions.
Exactly. Ugandan law allows statements from someone who's dead or unavailable about the circumstances of their death to be admitted as evidence,
Hmm.
even if they weren't literally dying when they said it.
Interesting. It's like the law recognizes that sometimes those last words can be crucial.
And Judge Wagona uses this to illustrate a bigger point. Always be searching for every piece of evidence that could help, even if it's unconventional.
Leave no stone unturned. I like that approach. What else?
He brings up a real problem in Uganda: missing exhibits. Apparently, because of storage issues, evidence sometimes goes missing.
Oh, wow. That's a major obstacle. What can you do about that?
He says you have to explain why the exhibit is missing, and then use witness descriptions to fill in the gaps.
So even if you don't have the actual murder weapon, you can still use witnesses to describe it.
Exactly. Be adaptable.
Ah.
Now get this. Judge Wagona also talks about how culture affects trials.
Oh, I'm intrigued. What does he say?
Well, he tells this story from his time in Moroto. It's a region in Uganda with strong traditional practices.
Okay.
And he noticed that a lot of cases are basically pre-tried in the village, like before they even get to an actual courtroom. There's this whole informal system of resolving disputes that happens first.
Wow, so there's like a village court that happens before the official one. That's fascinating. It really shows how much context matters.
Right. And he also mentions that attitudes toward things like plea bargaining can be totally different in different communities.
Yeah, what might be seen as a practical solution in one place could be completely unacceptable in another. It all depends on the cultural norms.
Exactly. So prosecutors can't just use the same approach everywhere. They need to be aware of those differences and be sensitive to the local customs.
It's a good reminder that law isn't just about rules on paper. It's about people and how they interact with those rules.
He's really advocating for a more nuanced approach, one that takes those cultural factors into account.
Judge Wagona's presentation is a goldmine of information. What else does he touch on?
He wraps things up with some advice on final arguments and sentencing. He reminds prosecutors that they're speaking to both the judge and the assessors.
Right, those mini jurors we talked about.
And even though the assessors don't have the final say, their opinions can influence the judge's decision.
So you're trying to persuade multiple people at once. It's like a double whammy.
He also criticizes those prosecutors who just demand harsh sentences without giving good reasons.
So don't just say throw the book at them. You need to back it up with solid legal arguments.
Exactly. Be thorough and persuasive every step of the way.
Wow, this deep dive has been incredible. So much practical advice and fascinating insights from a judge who's seen it all.
It really makes you appreciate the complexity of the legal system.
And it makes you think about how law and culture are intertwined.
Absolutely. One last thing that really stuck with me was Judge Wagona's reminder that the law isn't static, it's always evolving.
Yeah, it has to adapt to keep up with society.
And it's up to legal professionals to not just understand the law as it is, but to also think about how it should be.
It's a call to action, in a way, to be more than just rule followers, to be critical thinkers who are shaping the legal landscape.
So what were your biggest takeaways from this deep dive?
I think what resonated most with me was Judge Wagona's emphasis on cultural awareness and the human element of law. It's a reminder that being a good prosecutor isn't just about winning cases. It's about understanding the people you're serving and working within their cultural context.
Could agree more. It's about bringing those different perspectives into the courtroom and striving for a more just and equitable system.
That's a perfect note to end on. So, if this deep dive sparked your curiosity, I encourage you to keep exploring the world of law. Read about cases, maybe even observe a court session in your area. You never know what might ignite a passion you didn't know you had.
And on that note, we'll wrap things up. Until next time, keep those minds curious.
Oh.